Welcome to This Explainer. Today, we're unpacking how the criminal justice system actually works. We are stripping away all that Hollywood drama to reveal the fascinating and honestly, sometimes shocking reality of it all. We're going to look closely at the true mechanics of our courts, the people who really run them, and how criminal cases genuinely move through the system from start to finish.
All right, right off the bat, I need you to abandon the idea of constant surprise witnesses and those highly theatrical screaming matches. I mean, sure, those make for fantastic television, but the real courtroom, it's much more structured, deeply procedural, and, I would argue, wildly interesting in its own right. It operates on a highly specific set of rules and boundaries that are intricately designed to balance the massive power of the state with the constitutional rights of the individual.
So, here's our roadmap for This Explainer. First, mapping the court system. Second, the Courtroom Workgroup. Third, pretrial steps and bail. Fourth, the Plea Bargain Reality. And finally, juries and jury nullification. Let's jump right in.
Section 1, mapping the court system, jurisdiction and structure. We really have to start by establishing the playing field, which the legal system refers to as jurisdiction. This simply means the specific boundaries of what types of cases a court is actually allowed to hear. Because without it, a court has literally zero authority to make any legal decisions whatsoever.
Now, the United States operates on a dual court system. This means we have federal courts specifically handling violations of U.S. government laws across state lines, while each individual state has its own completely unique court structure tailored for local offenses. And while their specific titles might change depending on what state you're in, they all share a basic operational hierarchy. And you know, this overlap brilliantly illustrates just how complex jurisdiction can get. Situations like state-level marijuana legalization create what we call concurrent jurisdiction. So, in places like Colorado, an action might be perfectly legal under state law, but still be considered a federal crime. It's a fascinating, highly contentious clash where both sets of legal gears are just grinding against each other. Beyond just geography, we also have subject matter jurisdiction. This divides courts into limited jurisdiction for highly specific issues like juvenile courts, family courts, or drug courts, and general jurisdiction for the high-level felony trials we typically picture, your murder or assault cases. This division is absolutely crucial because it ensures that highly specialized issues are handled by experts in that field rather than severely clogging up the main trial courts. Finally, there's appellate jurisdiction. Now, there is a major myth out there that appeals are just a do-over for a guilty verdict. They're not. Appellate courts actually serve as a strict check to review if the legal rules of the game were properly followed during the original trial. They aren't looking at guilt or innocence at all. They are exclusively looking at whether the rules of the game were played fairly. Section 2, the Courtroom Workgroup. Just co-workers in an office. Let's introduce the people actually inside the courtroom.
Instead of viewing them as bitter, sworn enemies locked in this endless battle, think of them as the Courtroom Workgroup. Despite their adversarial roles on paper, they are essentially an office of co-workers who share a daily workspace and desperately need to keep this heavy system moving. The core members include the judge, who acts as an impartial referee, the prosecutor, who represents the state and carries the heavy burden of actually proving guilt, and the defense attorney, who fiercely protects the defendant's due process rights throughout the entire complex ordeal.
This brings us to a really crucial point. Defense attorneys are absolutely not there to lie or cover up for criminals. Their ethical duty is to rigorously maintain our constitutional presumption of innocence by forcing the prosecutor to undeniably prove their case beyond a reasonable doubt. If a factually guilty person is acquitted, that is a failure of the prosecutor to meet their heavy burden. It's not some trick by the defense. It's all about maintaining the integrity of due process. Meanwhile, the judge acts as the ultimate authority on what evidence is allowed and often determines the final sentence. You might be wondering how judges actually get this immense discretionary power over people's lives. Well, the reality is that many states select them through popular public elections, and that brings its own totally unique set of political pressures into the justice system. After all, a judge running for re-election might feel immense public pressure to appear tough on crime when they're handing down a sentence.
Moving right along to Section 3, pretrial steps and bail. The journey begins. Now that we know the architecture and the key players, let's trace the actual chronological journey of a criminal case.
There is a massive amount of process that happens before anyone even sits in a jury box. It steps systematically.
First, the initial arrest. Then, an appearance before a judge within 24 to 72 hours to formally hear the charges. This is quickly followed by a bail decision, and finally an arraignment, which is where the defendant looks the judge in the eye and enters their official plea of guilty, not guilty, or no contest.
Now, here is a massive misconception we need to clear up right now about this pretrial journey. Is bail actually a fine or maybe a punishment for being accused of a crime? Because think about it, if we presume people are innocent until proven guilty, locking them up simply because they were arrested seems totally contradictory, right?
The answer is that bail is absolutely not a fine. Nope, it is simply a financial promise to return to court. Think of it exactly like a code check. You leave something of value, and if you show up to all your required trial dates, that money is entirely returned to you. The whole shebang. And that's regardless of whether the final verdict ends up being guilty or innocent.
And get this, the Constitution doesn't actually guarantee bail for everyone. It only protects against unreasonable bail, meaning bail has to be scaled appropriately to the defendant's wealth and flight risk. That is exactly why a billionaire's bail will look vastly different from an average citizen's. The amount has to be high enough to actually hurt if they flee, which means true equality under bail is highly relative to a person's bank account.
Section 4, the Plea Bargain Reality, Efficiency versus Due Process. Okay, we are now at the stage where we must absolutely shatter the biggest illusion of the entire criminal justice system, the expectation of a grand dramatic trial. Because the truth is, our system is structurally designed to avoid trials at almost all costs.
Here is a frankly staggering reality. Roughly 95% of all criminal cases in our system never see a trial. Ever. Instead, they are resolved quietly behind closed doors through plea bargains. With public defenders managing overwhelmingly massive caseloads and courts deeply backlogged, honestly, without plea bargains, our entire court system would instantly grind to a halt.
We have essentially developed a plea bargain culture. The constitutional ideal of strict due process gives way to the need for extreme efficiency. Instead of a jury of peers weighing evidence, the prosecutor gets a guaranteed win, defense attorneys can clear their massive overwhelmed caseloads, and the defendant gets a predictable, though often completely life-altering, outcome.
But you know, the dark side of all this relentless efficiency is deeply, deeply troubling. Factually innocent people are sometimes pressured into accepting a guilty plea simply because they are absolutely terrified of facing a much harsher sentence if they happen to go to trial and lose. When the threat of decades in prison is dangled over someone's head, efficiency completely subverts the core goal of justice.
Which brings us to Section 5, Juries, the ultimate wild card. For that rare 5% of cases that do actually make it to a trial, the ultimate decision-making power rests with the jury.
This is a group of citizens meant to objectively represent the community, tasked with deciding the profound fate of their peers. But juries face some really enormous challenges. Everyday citizens, like you and me, often significantly misunderstand the strict burden of proof. Instead of properly presuming innocence, human nature often leads us to accidentally presume guilt right out of the gate. And, let's be real, without legal training, juries often allow their own personal emotions to heavily influence what should ideally be purely objective legal decisions.
And this leads us to one of the most fascinating and controversial things in the entire legal world: jury nullification. This happens when a jury looks at all the evidence, completely agrees the defendant is legally guilty beyond a reasonable doubt, but absolutely refuses to convict because they sincerely believe the law itself or the resulting punishment is inherently unjust. They essentially just throw out the rulebook.
So it leaves us with this highly provocative question to end on. If a jury deliberately ignores the strict rules of the courtroom to serve their own view of fairness, is that the ultimate form of community justice, acting as a vital check on state power, or is it a complete corruption of the legal system? I want you to think deeply about that the next time you hear a courtroom gavel fall. Thanks for joining me on this explainer.